Hello everyone. చెప్పండి చెప్పు తెలుసు లేదు కాదు. If you can understand the meaning of that phrase, awesome. Otherwise, it's also fine. There's no meaning of that phrase. So we will talk about 50 most important current affairs, polity and governance, part 2. Whoa. And again, these are all standalone parts. You can watch like first 13 most important current affairs we have discussed in part 1, and we are continuing from there in part 2. My name is Shubham Saga. You can connect with me on LinkedIn. This is my Telegram channel. I share Hindu analysis, which I do Monday to Saturday, which I try to upload by 9 a.m. every day, between 9 a.m. to 10 a.m. So, and I upload PDF of that Hindu analysis every day by 9 p.m. on this Telegram channel. So you can join this Telegram channel so that you can become disciplined with your current affairs. Oh my good, guys. So 14th most important current affairs. See, these are all standalone articles, and 14 does not mean in the hierarchy this is at the 14th number. No, all 50 articles are equally important. So what is this whole thing? During the Bihar election, 4th September 2025, Tejasvi Yadav, he said that if he's brought to power, which he did not come to power, he would increase reservation to 85%. That raised a question about reservation or a positive affirmation in India, which is guaranteed under exceptions under like Article 15 and 16, mostly under Article 15 and 16 of Indian Constitution. Currently, how much reservation we have at center? Percentage vary from state to state. In center, you have 59.5%. Earlier, it was 49.5% before EWS came into picture, and now it is 59.5%. Supreme Court is talking about, like, within ST community, you have one Meena community in Rajasthan, which gets or which occupies a lot of seats in ST community. Similarly, so they are asking whether there should be a creamy layer system for SC and ST or not, just like you have a creamy layer for OBC. So these talks and discussions are going on, and they're important talks and discussions that it will bring into picture different kind of judgments, and then we'll see which kind of pre-questions can be framed on them. Very important, very sensitive also. Balaji versus Mysore, reservation must be reasonable, capped at 50%. So it's an exception to equality, and it should be an exception rather than a norm. In current day and age, it has become a norm. Indra Sani ma'am, she upheld 27% OBC quota. Mandal Commission, they came up with this, but she introduced this particular judgment came up with creamy layer for OBCs. Remember, they can directly ask you which of the following judgment introduced creamy layer for OBC. Indra Sani judgment of 1992 reaffirmed 50% ceiling except in special case. Janit Habyan, this whole particular case came after EWS 10% quota was given to economically weaker section, even within general community, and it ruled that no, 50% cap is only for backward classes. Social discrimination. EWS is economic criteria, so this 50% ceiling does not apply to EWS. Many people even debate whether we should have an economic criteria for reservation, because economic criteria is a transient criteria. You may be poor today, you may not be poor tomorrow, but if you have been socially discriminated 10 years back, there's a very high chance that your family will be socially discriminated today also. Fahiyan, Chandragupta, Doma, Chandalas, Badhataus, there are so many references which we have read in previous day and age book, how this whole Varna system came into picture. Punjab and Davinder Singh, judges urged government to consider creamy layer within SC/ST reservation also, as we have discussed, Meena community, awesome community, but many people feel within STs they have got a dominant representation. What about other STs communities? We'll talk about this. Ambedkar sir also talked about reservation is necessary, but B must be limited to minorities. Pro-reservation expansion has happened. Backward communities are saying that, let's say we are more than 60% of the population, so our reservation should be matching that proportion share or population share rather, and that's why we need a caste census, which will happen in census 2027, where if backward classes are 60% of a particular population of a state, so in the state reservation system, maybe they should get 60% reservation. Practical issues: 40-50% of reserve seats remain vacant in central government jobs. So sometimes what happens, these SC, ST, etc., if there are talks related to introducing creamy layer within SC, ST, if that happens, currently many seats in these reserve portions, especially SC, ST, they remain vacant, and then they convert to unreserved. So if this creamy layer is introduced, maybe that thing will increase more. Reserve seats, vacancy, or the vacant reserve seats will increase more. You will understand each and everything. Just be with me. We'll solve some questions. You will remember each and every fact. This is basically a tricky article. The other articles which you will see after this will be much easier. So Rohini Commission, 97% of OBC quota benefits taken by 25% of OBC subcaste. As we have discussed in STs, Meena is considered ST in Rajasthan. In some regions, they are also considered as OBCs. So 1,000 OBC subcaste, they have zero representation. So in OBC also, you see why there is a need for subcategorization. Similar benefit concentration exists in SC/ST reservation also. One, two dominant communities, they are occupying most of the SC or SC seats. So no creamy layer exclusion for SC, STs. Debate is ongoing. Whether we should have, just like we have creamy layer for OBC, should we have a creamy layer for SC, STs or not? You know, it's not basically targeting Meenas and all. I love Meena. There's so many good friends of mine who are Meenas, but yeah. Argument against creamy layer for SC, ST. As we have just discussed, there are anyway many vacant reserve posts, which are later on converted into unreserved posts. So if you again introduce one more categorization within SC, ST, that is creamy layer concept, then it will lead to more vacancies, you know, because less people will be able to fill form in that reserve category. More vacancy means again, you are just going away from the whole concept which you aspired for. You want to fill these reserve posts. You don't want to keep them vacant, right? So many reserve posts remain unfulfilled and unfilled rather unfulfilled. So creamy layer exclusion may increase backlog. Risk of backlog vacancies being converted to unreserved seats, reducing ST opportunities. So we have to think about it, whether we actually need a creamy layer within SCST or not. Way forward, raising reservation to 85%, as Tejasvi Yadav was saying. Tejasvi was only saying, right? Yeah, leader of opposition Bihar. So it's violate right to equality of opportunity. Think about general category, guys. I am a general category student. Give all seats to, like, reserve all the seats. Then again, there has to be a limit somewhere. Some line has to be drawn somewhere. After 2027 census, which will include caste data, we can have discussions to fix, you know, suitable reservation levels. Subcategorization, as Rohini Commission was saying, do we need that? Among OBC is necessary. They are also in OBCs. There are certain categories which is hogging most of the seats. For SC/ST, two-tier system, prioritize the most marginalized within these groups. So again, you can read all these things. Only reservation will not do. Skill development, employability, all these things have to be taken care of. This is from mains perspective. Let's focus on pre perspective. This is 50 most important current affairs for P. Polity and governance. Which of the following articles empower the state to make provision for reservation? Mainly, you have to choose the best option, guys. Oh my god, look at that question, as Nicki Minaj would say. No, Nicki Minaj songs for you people, you're less than 18 years. Nicki Minaj is only for older people. So B, like 2 and 3. B, 2 and 3. Wow, guys, see this. Which of the following correctly represent total reservation percentage of reservation at the center? 59.5% C. Wow, guys. Which of the following arguments are commonly advanced against the app? This is a good question. Pause me whenever you're seeing this question. As somebody used to say in Chattanu, it's Manu too. Your question is a good question, but your question hurt me. So this is a good question. Pause me and try to solve it. What is the rationale given against the application of creamy layer for SC and ST? Large number of reserve posts remain vacant. Exclusion of creamy layer may increase backlog. Backlog vacancies may eventually be converted to yes. All the 3 points. You know, there are anyway so many vacant seats, reserve seats, and if you introduce another layer inside SC/ST reservation, the seats vacancy will increase, reserve seats vacancy, or the vacant reserve seats rather, and that will later on be converted into unreserved seats. So the whole premise of giving reservation to SC/ST will fail in that regard. So D is the answer. Yes, all of the arguments are commonly advanced. Which of the following judgments introduced the concept of creamy layer in India? Creamy, creamy, Britannia cream biscuit. No. So this is creamy layer. So the answer is Indra Sani, 1992. Whoa, guys. Next article, 15th most important article, 13. We have done in part 1. Whoa, guys. Let me pause for the movement. So accept Aadhaar as identity proof. Just again, 9 September 2025, when Bihar election was going on, Sir was going on special in this whole intensive revision exercise, and they were not accepting Aadhaar. They were accepting 11 documents, and election commission was like, Aadhaar is not a proof of citizenship, it is a proof of residentship. Then Supreme Court was like, dude, whatever 11 documents you are using or accepting as proof, most of those documents are not conclusive proof of citizenship. So if you're accepting those 11 documents, why are you not accepting Aadhaar? So this to and fro discussion, how good or bad is Sir special intensive revision, we'll talk about it. But more important than that is, what is Aadhaar? Once your Aadhaar is there, you know, can it be deactivated or deleted? Yes, once you die, it will be deleted, and it can be changed also. So first, these things are important. UPSC has already asked PYQ on Aadhaar, and then we will go and see the whole argument. 12-digit unique identification number issued by UIDAI, that is Aadhaar, your fingerprint iris scan, and this is actually, you know, very sensitive data, because I cannot have two fingerprint, two iris scan, right? It's unique to me, right? Enrollment is voluntary, but Aadhaar has become a wide, like, what is voluntary? Many people believe that government has pressurized people to go for Aadhaar, just like they did things for demonetization. I will not go there. So it is a has statutory backing. Aadhaar Act 2016, targeted delivery of blah, 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 blah. So do remember, it has a statutory backing. It is 12-digit unique identification number, and These things are important. Aadhaar is only recognized as proof of residentship's identity. It is not a proof of citizenship. Just like you have birth certificate, you have passport, they are proof of your citizenship. Aadhaar is a proof of your residentship. You live in India. So that's why Election Commission was not accepting Aadhaar as a proof that you should be allowed to vote. Then Supreme Court was like, no, allow. 12th indicative document it will be for inclusion and exclusion of people, and they are saying that the existing 11 documents which you're using as a proof, they're also not, most of them or many of them are not conclusive proof of citizenship either. So if you accept them, why don't you accept Aadhaar? Accept it, man. And this to and fro discussion happened. People are anyway very much perturbed by this Aadhaar means sir thing and special intensive revision. Not that this is bad, yes, it is good, but the way it is being conducted, and there is so much non-uniformity associated with sir. In Bengal they're doing other way, in Bihar they did other way. Again, we'll talk about sir in one separate article, don't worry. So senior advocate Rakesh Dwivedi, you can read all these things. 19, and he was saying that people stated no political parties have reported errors in SAR process. Again, this is the advocate standing for Election Commission. So what he will say? All political parties have reported errors in SAR process. He will not say that, right? How many people have been excluded? Now, this is one argument which you can use in means, not in pre right now. That Election Commission work is to ensure a universal adult franchise under Article 326, right to vote. The work is not to ensure people are not getting right to vote, disenfranchisement, or not to ensure who is a citizen of India or not. There are other machineries to ensure or to check who is a citizen of India, who is citizen of, or who is not a citizen of India. You have Ministry of External Affairs, Defense. There are different departments within that, but there is no entity in India which will ensure universal adult franchise other than ECI. So the ECI's work is positive to ensure people can vote, not to ensure who cannot vote. That is, or who is not a citizen of India. Citizenship proof should not lie with ECI. That is a debate which is going on. Then you have other entities to look into that. Chepandis, Chepo, guys. No Chepandis, Chepo, I will kill you all and eat your life. Hey. So you can read all these points in your own free time. You know what is important here. This thing, Aadhaar, statutory backing. It can be deleted, Aadhaar. It is not a proof of citizenship. Remember these facts because they are really important. How important? Not very important. They are really important. I love you now, Piliya Poina. Aadhaar can be used as proof of citizenship? No, residentship. Once issued, Aadhaar cannot be deactivated. Wrong. It can be deactivated or omitted. I love you. So, oh, sorry. So this two is also one. So the answer is D, 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 D. D for dog. Who is a good boy? Guys, MCQ. With reference to Supreme Court recent orders on Bihar electoral rules, consider the following statement. Consider it. Why people do like this? I love you know, Piriya Dipoina. There was a song in our time. You people were not born. Allu Arjun was the actor. Aadhaar has been added. So Aadhaar can be used. So let's say you don't know these data about Sir. You're not following Sir minutely, but second statement is wrong. It is not a proof of Indian citizenship, residentship. So eliminate second. Use option elimination. Become a smart guy. Convert yourself from a hard-working guy to a smart guy. So the answer is B. 1 and 3 only. Oh, guys, I was supposed to do well. 16th article. 20th September 2025. Good stalling. Again, so what I have done is I have clubbed all ECI related articles at the same time, at the same place, right? So we are talking about ECI, Election Commission of India, and there's one quote: election should not only be fair, it should also be seen as fair in world's largest democracy. So there are people who have some issues related to ECI, Article 324. You have election commissioner, chief election commissioner, and two other election commissioners. They are all they have equal power. ECI, CEC is just first among the equals. Remember this. They are there for 6 years or 65, whatever comes earlier. So remember these facts and become a very good boy or a good girl, whatever. So ECI, Rahul Gandhi, you may like Rahul Gandhi, you may dislike Rahul Gandhi, you may like Modi ji, you may dislike Modi ji. That is not the point here. The point is there were some issues in Alan constituency, Karnataka. 6,000 legitimate voters, their name was they were tried to be deleted, and that is being seen. These kind of things have been happening here, there, everywhere. So ECI prevented the deletion, but they did not disclose the destination IP and port data, which were trying to delete these information. CID, Crime Investigation Department, if I'm not wrong, just like you have CBI at the center. Under DSPE Act, Delhi Special Police Establishment Act, that is for CBI. In state, the Crime Investigation Department is CID. It looks within the state. These, they are the detective entity of the State Department. So within a state, you have CID. At central level, you have CBI. CBI statutory backing via DSPS. Oh my God, Delhi Special Police Establishment Act. So CID prop was going on, but because ECI is not telling the IP and destination port, they're not able to find out the whole rationale who was trying to do this fraud. ECI admitted fraudulent attempts occurred, but it has not answered the core allegation why it is withholding critical technical documentation from CID. So again, whatever be the reason, but EIC had to be more transparent, because election should not only be fair, they should also be seen as fair. Without IP port data, CID cannot track these frauds. It's like finding a needle in a haystack. You can read all these things. EIC credibility already under strain due to, again, I love Modi ji, I love ECI. I have a group photo of Modi ji and Amit Shah in my heart. So quick analogy: local police handles street crimes. CID, state level detective branch. Remember, they can do work within their own state. They cannot do work, like all over India. No, that is CBI, country's premier investigation agency. There is no CBI Act. There is DSP Act, Delhi Special Police Establishment Act, via which they get their power, backing, blah blah blah, statutory backing. Election Commission, Article 324, carry out elections of Parliament, State Legislature, President, Vice President. But the dispute, election related dispute, that is decided by High Court and maybe later by Supreme Court. That whole dispute resolution thing is not the work of ECI, keep it in mind. CEC, and earlier there was only one CEC. After 1989, you have one CEC, two ECEs, they are all equal, they have equal powers, but CEC is first among the equals, but the process of removal of them is actually different. You can read it, 65 or 6 years. Remember these facts, they are very important. Not important. Important means something else that you cannot produce. No, important. PYQ UPSC 2004. You see all the functions and see and try to answer this. Which of the above functions of ECI use option elimination and become a good boy or a good girl? Whoa, guys. Why do people do wow wow? I love you na ఊపిరియాది పోయినా I love you na pranam పోయినా iti kuntadi prem ki. In our time there was a song Allu Arjun Arya 2. నువ్వుంటే నిజమేగా సత్యం నువ్వుంటే నిజమాగా సత్యం. That is Arya movie. So proclamation of final verdict in the case of election dispute, that is not the work of ECI, guys. That is the work of High Court mainly, and then maybe Supreme Court. So not ECI. Fourth, you eliminated. Now you have to check second one. We don't need to check first and third. Option elimination. Read all statement. The more statement there are in UPSC PYQ, the easier that question is. You can do option elimination. So don't get bogged down that, oh my God, there are 5 statements. I got excited. So we don't have to check first and third. Second, preparation of electoral rules for elections of parliament. Yes, that is correct. So the answer is A. 1, 2, and 3. Wow. Wow. Which of the following statement about CID in India is correct? Use option elimination. Read all statements. Don't get like, oh my God, sir, you did not tell much about CID. Use option elimination. Second is wrong. It cannot investigate case anywhere in India within their state. So second, eliminate second. You don't need to even know anything about 1 and 3. C is the answer. Wow. Yeah. Wow. Consider the following statement regarding tenure and removal of ECs. Chief Election Commissioner can be removed only like a Supreme Court judge. Maybe you don't know these stuffs. Again, maybe you don't know the removal process. This is your homework. Read it and become a good boy. Static and dynamic portion are merging here. Wah, wah, wah. Again, wah, wah, wah. I love you. Now, Piriya. So, tenure is not 5 years or 62 years, 6 or 65. So, third is wrong. The answer is A and 1 and 2, even if you don't know. Chief Election Commission can be removed like Supreme Court Judge, CC, and other can be removed on the recommendation of CC. So you see, although they're first among equal CC, but still the removal process is different. Same, but different. No money, no honey. A is the answer, 1 and 2. Guys, be serious, okay? If you feel like my speed is too high, you can watch me at 0.75. If you feel like my speed is too less, you can watch me at 1.25. Different students, different problems. I have seen this. Okay. Again, all ECI related articles at the same time. Center says right to vote, not same as freedom of voting. Right to vote, UPSC is already asked a PYQ. We'll have a look at that. Now the answer may be different. Like that year when right to vote question was asked by UPSC, they gave one answer. Maybe this year they will not give that particular answer. Maybe the answer will be something else. Oh my God. So what they are saying, right to vote, according to government right now, government is saying that right to vote is a statutory right. See? So I will show you the question which was asked by UPSC, which created a lot of ruckus, guys. Rakku, rakku, pakku, kakku. Oh, sorry. Ruckus means like right to vote and be elected in India is what? UPSC 2017. And they gave the answer as constitutional right. Many people take legal right. and they used Article 326 as the point that right to vote is and be elected is constitutional right. Now even government is saying that no, it's not constitutional, it's a statutory, that is a legal right, and it is coming from RPA 1951. On the other hand, they're saying that right to vote is a statutory legal right under RPA 1951. So there are two things, guys: RPA 1950 and RPA 1951. This RPA you will read in your mains syllabus, Representation of People's Act. 1950 is basically about electoral rules: who will vote, who will not vote. There is Form 7, by which your name can be removed, and all these things are under RPA. RPA 1951 is like people who are contesting elections. How much money they can spend, model code of conduct, how it will be implemented, blah blah blah. So all these provisions are there in RP 1951. Remember this. So right to vote, they are saying, government is saying, center in its affidavit, they are saying right to vote is under RPA 1951, legal right. On the other hand, freedom of voting, it's a choice, speech and expression. So it is under Article 19(1), Clause A. 19 Clause A1 subclause A of the Constitution. So, and freedom of voting, right to vote is a prerequisite of freedom of voting. Please understand, this is tricky. This article is tricky. So right to vote, whatever means UPSC said that it's a constitutional right, etc. Now government is saying that no, it's a statutory right, and they are not same. Right to vote and freedom of voting is not same. Freedom of voting will only come into picture if you have right to vote. Why all these things are happening? Because there is a case which has been filed against government. So what government did was, I will tell you. I will tell you the whole issue. First of all, look at it. This is a tricky article, guys. Go through it again and again. Right to vote is a statutory right according to Supreme Court. It means government legal right under RPA 1950. Freedom of voting, it's a part of freedom of speech and expression under Article 19, Clause 1, Clause A. You have freedom of voting only if you have right to vote. So hope you are understanding. If I have a right to vote, only then I can go and I can vote for anyone I want to, right? So the case concerned regarding uncontested election under Section 53 Clause 2 of RP 1951. And so what government did was, there was a uncontested election which happened because there were 5 people, and let's take an example. There are 5 people who are contesting and there are 5 seats. In that scenario, there is no need for an election. That is an uncontested election. If there is no election, then there is no right to vote. If there is no right to vote, there is no freedom of voting, right? So that's what ADR and VD Center is saying, that why you did not have election. It goes against, it violates our right to vote and all. So case concern uncontested election which happened, and if the number of, and why there was no election, because this provision was fulfilled under Section 53, Clause 2 of RPA 1958 of 51. Number of candidates equal the number of available seats. The returning officer must declare all such candidates are duly elected. That's what happened. But ADR and Vidhi Center is saying that not conducting a poll in contested elections violates citizens' freedom of speech and expression, that is freedom of voting, under Article 19, Clause 1, Subclause A. Citizens are denied the chance to express nota. We will not select anyone, none of the above. But nota does not have that backing. Nota is, you just used to protest it. It's not like if nota gets the maximum number of votes, nobody will be elected from that seat. That does not happen currently in India. Maybe it will change in future. We don't know. Both the center and ECI have addressed whether declaring a single candidate elected without polling violates elector rights to use nota. Center is saying that freedom of voting or freedom of speech and expression comes when right to vote is there. When the election did not happen, right to vote is not there. When the right to vote is not there, where is the freedom of voting? Where is freedom of speech and expression? So that's what center is saying. Right to vote arises from Section 62 of RPA and is limited by statute. Freedom of voting is a form of expression under freedom of speech and expression, Article 19, Clause 1, Subclause A. Center cited 2003 Supreme Court judgment. Right to vote is not a fundamental right, constitutional right, and not a fundamental right. I seriously don't understand why they said it's a constitutional right, why not legal right. Again, it's none of my concern. But when a voter casts a vote, it becomes an act of expression. Freedom of voting, that is a form of freedom of speech. Please understand, guys. Right to vote, statutory right under RPA 1951, which UPSC believes to be a constitutional right under Article 326 of Constitution. Freedom of voting is a part of freedom of speech and expression under Article 19, Clause 1, Subclause A. Center's key submission: freedom of voting, whether positive or negative or nota, exists only when a poll is conducted. If there is no poll, uncontested election, no freedom. So right to vote is a prerequisite of freedom of voting. According to Center, freedom of voting is contingent upon existence of a poll. And since, again, you can read all. Don't forget about section fiction. Just remember the relationship between right to vote and freedom of voting via this particular awesome article. Awesome article. You can read it in your own free time if time permits, but not needed right now. Maybe in mains, if you have some issues, you can contact me and we'll have more discussion on this. This is actually an awesome article. Right to vote, statutory right under RPA, freedom of voting, fundamental right under article, or freedom of speech and expression. Meaning eligibility to vote, freedom of voting means I can vote anyone I want to, I can vote to nota. So read all these things. Right to vote lets you participate, freedom of voting lets you choose whosoever you want to choose. You want to vote for Shubh, you want to vote for somebody else. I love one name, guys. Mathili. Mathili. Right to vote and be elected in India, constitutional right according to UPSC 2017. Next question. Which one of the following best describes the relationship between right to vote and freedom of voting? What have we just discussed? Read all the statements and try to do option elimination and become a really good boy and really good girl. So the answer is right to vote is a prerequisite for exercising freedom of voting. Wow. Ooh. As Radhakrishna sir elected Vice President of India. So now here Radhakrishna sir, yeah, we're very happy about him. Congratulations, Radhakrishna sir. More important here is the process of election of Vice President and President. Comparative analysis, guys, smart study. Vice President election, you know, all MPs of Rajya Sabha and Lok Sabha, elected, nominated, doesn't matter. Vice President. On the other hand, President, elected MPs of Lok Sabha and Rajya Sabha, elected MLAs. So remember this difference. There is a difference here. In president election, there is weighted system. You know, votes have weight. In here, every MP have one vote. So weighted system means MPs, their votes will have different weight and MLAs will have different weights. Their MLAs also, their votes will vary according to their state's population. So all these things are there. Value of vote of an MP is decided by, you know, you will take values of vote of all MLAs divided by total number of MPs, elected MPs, and then you will get the value of vote of MP. Remember these static things, they are important. Important. My God, why I can't be serious, guys. Election. Maharashtra Governor C.P. Radhakrishnan, 17th Vice President. From UPSC perspective, guys, 17th Vice President, 67 Vice President. These numbers are not important. The process of election of Vice President and President, they are really important. Cool. Cross voting, etc. Blah 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 happened. You read all these things. Modi sir is very happy. Wow. So electoral college. This is important from exam perspective. President, elected MPs and MLAs. Elected MLAs, not nominated. Sachin Tendulkar, when he was a nominated MP of Rajya Sabha, he could not have come for this president election, but he could have voted for vice president election because he was a nominated member of Rajya Sabha. In president, votes are weighted based on population proportional representation. Vice president, MLAs have no role. Votes are not weighted. One MP, one vote. Remember these things. All members of parliament, elected, nominated, etc., they can take part in vice president election. Really good. Vice president of India is elected by choose the option. Use option elimination and become a really good boy or really good girl. I love you na ఊపిరి పోయినా. I love you na ప్రాణం పోయినా. ఇటుకుంటది ప్రేమ్కి. So Vice President of India is elected by members of Parliament only. B. Just give me a second, guys. Oh. PYQ UPSC 2018 with reference to election of President of India, consider the following statement. Pause me and then try to unpause me. What do you think is the answer? Chapandis, Chapandis. So value vote for each MLA varies from state to state. Yes. So states with higher population, they have a higher vote, let's say a higher value. So let's say there is an MLA from, elected MLA from UP or Bihar. Those states will have higher value compared to an elected MLA from Assam because of higher population. So first is correct. Now you're left with ANC. Value vote of MPs is more than, no. MP of Rajya Sabha, Lok Sabha, elected MP, the value is same. It's just that it's the total value of, votes of all MLAs divided by total number of MPs. So second is wrong and the answer is A, 1 only. Value of an MP vote in president election is calculated by, pause me, unpause me, dividing total MLA votes by the number of elected MPs. B. Next article, 19th article, 20th December 2025, preamble. If you see the first part, the first article was related to preamble. There are many people who say that words like socialist, secular, etc. should be removed from preamble. So here Supreme Court is citing, like, there is a ma'am called Banu Mushtaq. She's a Booker Prize winner, if I'm not wrong, very famous, writer. She's a Muslim. So she was invited by Booker Prize winner, 2025 winner, you see, and she was invited by Karnataka government in this for opening the Dashara festival, and many people, they did not like it. They were like, no, Dashara festival, Hindu festival, why should a Muslim woman come and you know see this? A petitioner H.S. Gaurav from Bangalore objected to author Banu Mushtaq, a Muslim and Booker Prize winner, inaugurating Mysuru Dasara festival. So this petitioner is saying that there are two parts: ribbon cutting, secular activity, but temple puja and all is religious practice, and only a Hindu dignitary should have performed such religious practice. So then Supreme Court is saying that, bro, have you forgotten about Ismail Faruqi judgment of 1994? Have you forgotten that this is not a private event, this is a state event, and state is secular in nature? They are not discriminating people on the basis of religion. They can invite anybody they want to. So, because state is not religious, we have secularism as a feature. So the petitioner is saying that only a Hindu dignitary should perform ritual under Article 25, part of essential religious practice. So this is a political act again. Now, what was the justification given by Supreme Court? See this? They are saying that state of Karnataka is secular. This is not a private event. This is a state event, and state does not distinguish between religion. They don't distinguish. Before inviting a person, whether he's a Hindu or Muslim. This Hindu Muslim thing, now I have started seeing it after the Amrit Kal started in 2014. I have seen what Godi media they do is, let's say there is a Muslim, a Hindu perpetrator who did certain stuff, they will hide his religion. They will not say that his religion, what it is. But when there are some Muslim people involved, they will suddenly highlight his name Khan, or they will say Muslim this and that. I don't know why they do that. If you remember, there is one Sadhvi madam who was elected an MP. She was a terror accused, and she was a Hindu. So I firmly believe, you may disagree with me, I firmly believe religions are not bad. People are bad in every religion. I can give you example of enough people in every religion who were heinous, so to say. So yes. So state of Karnataka means secular, maintains no religion of its own, citing 1994 M. Ismail Faruqi judgment. And it's a state even, not a private program. So, and there were other judgments also, Keshwanand Bharti, S.R. Bomai, which held that secularism is a basic feature. And even before secularism was added in our preamble, before 42nd Amendment, which is a mini constitution, it was not like we were discriminating. State never discriminated. Equal treatment was happening. Balram Singh versus Union of India. State neutrality does not stop it from curbing religious practice that impede equality development. Let's say abolition of untouchability. That is one thing. Or uh, anything. You may be triple talaq. I don't know. Or Sabrimala case, menstruating women not allowed to enter Lord Ayappa temple. So there are things which we have to understand from secularism perspective. India follow positive secularism, unlike, let's say, in France or in Europe, where they have a strict separation between state and church. Here we promote, like, we have equal respect, and we can intervene in religious practices if they violate fundamental rights. At the same time, we can also give protection to minority religion. Faruqi judgment cited Swami Vivekanand, stressing religion, realization and not dogma. Swami Vivekanand, service of Jiva is worship of Shiva. Wow. Help a fellow human being and you are worshipping God. Constitution of India, remember it, guys. The number of questions which has been asked from, oh my God, my chapter like handwriting from preamble is huge. So remember your preamble. How many types of justice? Three. Social, economic, political. Liberty. How many types? Step four. Liberty of thought, expression, belief, faith, and worship. Equality, two types, status and opportunity. So, and when we gave ourselves this constitution, 26 November 1949, sovereign, socialist, secular, democratic, republic. So all these things, remember, mug up your preamble. In means they can directly ask you, write the whole preamble. They have already asked in pre multiple questions in preamble. Sarv Dhar Sambhav implies what? Again, this is based on your pre-existing knowledge. Try to, you may have heard this quote: state treats all religion equally. Whoa, does state? Like, is it true for current state India? Or, like, again, I'm not going there. Preamble is what? Preamble is a legally enforceable law, interpretive tool reflecting constitution philosophy, directive principles, religious texts. Use your current pre-existing, like, knowledge. So it's an interpretive tool reflecting the Constitution's philosophy. PYQ UPSC 2017. Which one of the following objective is not embodied in preamble? See this? That's what I'm saying. Chepandis, guys. Chepandis first. So you have. We were talking about liberty. So liberty, there was a mnemonic I told you. TEF for thought, expression, belief, faith, and worship. So thought you have, expression you have, belief you have. So economic liberty you don't have. They're asking not embodied. Sometimes they will highlight this not like this. Sometimes they won't. So you have to be ready for that. Like, share, and subscribe, guys. Spread the words. If I'm adding to your knowledge base, you can donate at this number. If you want this PDF, you can send a message to me at this number only. Next article, 20th. How are courts protecting personality rights? Personality rights. Do we have a single act dealing with personality rights? Personality rights mean what? Like currently we see, you may have seen those images, etc., where Shah Rukh Khan and Madhuri Dixit, they're doing something created by deep fake and all. Deep fake is what? Somebody else is doing it, but your photo has been or your face has been projected on that. So these things are happening, and that's what necessitates personality rights protection. And more actors and all, they're taking or they are going for protecting their personality rights. And I personally feel, why only actors? Later, even like it's not like common people, there is something called as revenge porn which is happening. What is revenge porn? So two people are in relationship, and because of some reason relationship broke, and then what happened? The relationship broke, and then one person used other person's images, etc., for some stupid things. Revenge porn. You can, even if you don't have the actual images, you can replace the face and all. So deep fake, revenge porn, all these things coming together. So it's not like it is these personality rights are needed only for these celebrities in this AI generated content era. It will be needed for common people as well. What are personality rights? And it's not only about protecting your name, image, face, and all. It's also about your traits, like Anil Kapoor, Jhakas. He took, personality rights for his whole Jhakas also. Nobody can use it without taking his permission and all. So, and do we have a single law for protecting personality rights? No, we have Trademark Law Act, Copyrights Act, different Supreme Court judgments, High Court judgments. So, no single law, but there are different laws, different judicial judgments, and all, via which we are talking about protecting personality rights, or courts are protecting personality rights. So, Copyright Act, Trademark Act, all these things are there. So this article is a mixture between polity, governance, and even science and tech. In science and tech, when you people will become 18 plus, you will prepare for UPSC. In GS Mains Paper 3, you will read about intellectual property rights. There you will read about copyright, trademark, patent, GI tag. So there are different words. Copyright is what? So let's say, uh, first of all, trademark. Let's say Parle G, Britannia. They have their own unique trademark, unique symbol, that is trademark. Similarly, celebrities, they also have this name signatures and phrases like Jhakas or Anil Kapoor. Copyright Act is what? A.R. Rahman, he composed a music. I wrote a book. I will get a copyright. Patent is what? No artist. They made a drug, medicine. On that drug, they will get a patent. GI tag is what? Unique to a particular means region. Darjeeling tea, Bengal Rasagulla, Odisha's Rasagulla. So all these things. Remember this? The difference between them. Constitutional basis, personality rights linked to Article 21, right to privacy. After K.S. Puttaswamy judgment, already UPSC has asked multiple PYQs on that in 2024 as well as 2021. So remember it and become a goody good boys and good girls. Wow, very good. Guys, please be serious, okay? I will kill you all and eat you alive. I won't. I'm not a cannibal. And if I have killed you all, I cannot eat you alive because you're already dead. See, it's a tricky statement. R. Rajagopal, Supreme Court recognized right to control identity use as part of privacy rights. Anil Kapoor case, injection against misuse of his person and catchphrase, chakas, chakas. Genuine satire and criticism is protected under Article 19, Clause 1, Subclause A, but commercial exploitation not allowed. And again, there is another point. In yes, personality rights have to be protected, but will it lead to can we not even criticize these people? Will it impinge upon Article 19, freedom of speech and expression? That is also one thing which we have to take into consideration. Article 21, privacy, personality rights, has to be balanced with Article 19, Clause 1, Subclause A, freedom of speech and expression. Arijit Singh voice cloning, all these things cannot be done using AI. Personality rights versus free speech. Article 21 versus Article 19, Clause 1, Subclause A. As we have just discussed, parody has to be then criticism. Even like if these things become too stringent, think about what will Sunil Grover do then on Kapil Sharma show. He did the parody of Amir Khan in such an awesome way. So personality rights also has to have some limitations and restrictions. So you can read all these things. There's no single law to talk about personality rights protection and all. We need a comprehensive or comprehensive legislative framework. You can read all these things. You hope you understood what is deep fake, what is revenge porn. Deep fake, you said it, but your face has been projected or replaced with Tom Cruise face. So it feels like Tom Cruise has said it. That is deep fake. Revenge porn, I have just told you. So read all these things in your free time. Will help you in pre as well as mains. But we are talking mainly from pre perspective right now. Che Pandis. So personality rights are primarily derived from common law principles and judicial precedents. I show you a question and then I pause because I speak breathlessly like Shankar Mahadevan. So I'm taking pause. In the meantime, you solve this question. Che Pandis. Chepa, chupa, chepa. Guys, please be serious, okay? I will kill you all. Article 19, Clause 1, Subclause A of Constitution of India guarantees what? What does it guarantees? Right to freedom of speech and expression. In the context of personality rights, Article 19, Clause 1, Subclause A protects what? Have a look at this. This is actually a good question. You can get confused. You can mark something wrong here. Chepandis, Chepandis, Chepandis. So it protects satire, parody, and criticism of public figures. 19 clause 2, I think it is on the restrictions of freedom of speech and expression or on freedom of speech and expression under certain scenarios. But 19 clause 1, subclause A, is about freedom of speech and expression. Which of the following articles has the Supreme Court placed right to privacy? Article 21. 2024 and 2021, they have asked the same question, guys. UPSC does that. Article 50 most important articles. 21st article, retrospective age limits under surrogacy law violates reproductive autonomy. Here what we have to focus is on traditional surrogacy, gestational surrogacy, commercial surrogacy, altruistic surrogacy. What is the basic meaning of surrogacy? So in India, commercial surrogacy is banned. Not only that, most of the people like commercial surrogacy is banned. Yes, commercial surrogacy is banned, but traditional surrogacy is also banned, guys. Traditional surrogacy as well as commercial surrogacy, both are banned. Most of the people, they don't understand this. What is this surrogacy thing? The opposite or somewhat opposite of traditional surrogacy is gestational surrogacy. So in India, altruistic gestational surrogacy is allowed. So commercial means you, like, let's say, let's go one by one. In traditional surrogacy, what happens? So the sperm comes from the father. The egg does not come from the mother, the actual mother. The egg comes from the pair, like surrogate. So in that way, surrogate is the mother of the child. Hope you're understanding. And that is traditional surrogacy. So she is carrying the embryo within her body, and she is also giving the eggs. The eggs and the sperm, they are fertilized, they become embryo, and then they are fertilized outside in vitro, and then it is planted inside the embryo. Like the embryo is planted inside the surrogate's body. So traditional surrogacy, surrogate is also the mother. In gestation surrogacy, that does not happen. Sperm comes from father, egg comes from mother. They are, in vitro fertilization is done, they become embryo, and then embryo is planted inside surrogate, and then surrogate just carries the embryo and she becomes a mother. So she's not actually the mother. I hope you're understanding. The mother is the one who, like, the mother is the mother who provided the eggs. So gestational surrogacy, that is allowed. In traditional surrogacy, eggs also come from surrogate. Embryo is also planted inside surrogate. Please understand these things. They are important. And let me show you, first of all, these terms so that you can understand, and then we'll talk about some other stuff. Let me also take a pause because I speak like Shanku Chanku, Che Pandis, guys. So couple wants a baby. Woman cannot carry a pregnancy due to medical reasons. So egg and sperm. Egg usually comes from woman who wants the baby, mother, intended mother. Sperm comes from intended father. Mother becomes sometimes confusing. People are like, surrogate is the mother. Fertilizer in lab, in vitro fertilization. Egg and sperm combine to form a embryo. Now embryo will be frozen for later use, or it can be implanted in the surrogate. Implantation in surrogate. Surrogate mother carries the embryo in her womb until birth, and surrogate undergoes normal pregnancy, birth, baby is given to intended parents. So this whole thing which you have seen, the egg usually comes from the woman. This is example of gestational surrogacy. Gestational. Surrogate mother carries an embryo created from intended parents or donors, egg or sperm. This is allowed in India. Process egg and sperm combined via IVF, in vitro fertilization, to create an embryo. Embryo is planted inside surrogate's womb. Surrogate has no genetic link. Traditional surrogacy not allowed in India. Surrogate mother's own egg is used. So the so-called intended mother, surrogate surrogate's mother should not be used. Surrogate own egg is used. Surrogate is artificially inseminated with intended father's sperm. Surrogate is biologically the mother of the child. So this baby shares genes with the surrogate. In the case of castration, she does not. So traditional surrogacy not allowed in India. Then altruistic surrogacy. Here we will not pay surrogate a lot of money, which is happening in commercial surrogacy, which is illegal again in India. In here, we will just pay for her medical and legal expenses. She will be generally a relative. So altruistic surrogacy allowed, commercial surrogacy not allowed, gestational surrogacy allowed, traditional surrogacy not allowed. In simple words, altruistic gestational surrogacy is allowed in our country. It's tricky, right? You have to understand these words, they're important. And then government came up with this Surrogacy Act in 2021. Supreme Court is right now saying that, and this act came into force from January 25, 2022. Supreme Court is saying that people who already did this whole thing, created embryo, maybe they have frozen it, they have not planted it inside the surrogate earlier, before January 25, 2022. So this surrogate law will not apply retrospectively. If people have done it before January 2025, 2022, things, in, frozen egg or embryo, etc. So they can go ahead with the things which they have done earlier. This whole surrogacy law, current surrogacy law, will not apply retrospectively on them. Rule on the applicability of age limits. Like currently in the Surrogate Act, Supreme Court or the Act has prescribed age limits. Who can go with this whole surrogacy thing? Altruistic gestational surrogacy. Women must be 23 to 50, men must be 26 to 55. So let's say this condition is not getting satisfied by men ages 25 only before, and but they did this whole thing before January 25, 2022, then this law will not be applied to them retrospectively. Couples who have already initiated the surrogacy process before the law came into effect. Age limits prescribed by the Act do not apply retrospectively. So hope you are understanding. If the woman age is, let's say, 22 or 51, so it will not apply to them retrospectively. It will apply if they have done it after January 25, 2022, whatever is the age limit or whatever is the starting point of this Act. Petitioner's case, three couples approached. They argued that they have already created preserved embryos. Hope you understood the meaning of embryo. What is embryo? What is gestational? What is traditional? What is altruistic? What is commercial surrogacy? These things are important, and these are the points which you have to keep in mind from exam perspective. This this whole thing is fine. This whole whatever we are discussing right now. Hence, they should not be qualified by the new age limits introduced later. You can read all these things. The Supreme Court is not saying anything bad about this act. They're just talking about a retrospective implementation when it comes to these age limits. That will not be the case here. This act will not be applied retrospectively, unlike, let's say, PM Kisan Act or National Food Security Act. Let's say PM Kisan Act, they came in a particular year, particular month, they will be applied, or they were applied retrospectively. They came into picture earlier when they were enacted, or like, hope you're understanding. Same case with National Food Security Act. Let's say they came in 2013, or but government said that they will be applicable from 2012. That can happen in retrospective act. This will not be like Surrogacy Act will not be that act when it comes to the age limit provision. That's what Supreme Court is saying. Exemption from age limits applies to all cases where embryos were created and frozen before the law's commencement, even if implantation into a surrogate mother had not yet occurred. Whoa. So you can have a look at all these points. Traditionally, we have discussed all the definitions. All very important, very tricky, very conceptual article, guys. Japanese, chepu. Guys, why you people do Japanese? So surrogacy, Supreme Court ruled that age limits under Surrogacy Act do not apply retrospectively to couples. B. In traditional surrogacy, which of the following is true? Traditional, gestational, we have discussed. Surrogates, traditional, surrogate's own egg is used, so she is genetically related to the child. Not allowed in India, traditional. Surrogacy Regulation Act 2021 prohibits commercial surrogacy. Article 22, Ladakh, Article 371, 6th schedule, how they are different from each other. All these points are actually important, guys. 23rd October 2025. So Ladakh, protest is going on. After they become a union territory, they want to become a state. They want provisions under the 6th schedule. They want more autonomy. Government is saying that we will give you provisions under Article 371. See, understand, Article 371 gives temporary provisions, and they have given temporary provisions to different states. It's not as exhaustive as 6th schedule. In 6th schedule, tribal autonomous councils are created. They basically have a lot of powers to rule their own council, own province, so to say, manage their police, pass some laws. That is not happening in 371, which is applied to different states, Nagaland, Assam, Manipur. They varies and they give some features, some protection, some provisions, not as exhaustive as sixth schedule. So Ladakh, different political bodies, civil society bodies like these two, I will show you. I love you, no, Piriyadi Poina. So there are two bodies. Like Sonam Wangchuk is in jail, right? So you have lay apex body KDA, and these are civil society groups which emerged after the protest started in Ladakh region after it was given a union territory status. They are like, no, this is so wrong. So lay apex bodies of Leh, Kargil, and Leh district, and Kargil Democratic Alliances of Kargil district, civil society groups, they're talking about all these things. They had discussion with MHA officials and they're like, no, we don't want Article 371. We want sixth schedule. We want statehood. We want proper representation. We want Sonam Wangchuk and other people to be released from prison. That is so wrong. Four people died. One Kargil war veteran was killed, man. This is so sad. Whenever I hear about, Ladakh, Sonam Wangchuk and all, I become very sad. Very sad. I don't know. Big criminals outside jail, and NSA has been invoked on Sonam Wangchuk. I don't want to comment anything on it. You know, so these two bodies, civil society bodies of Leh Ladakh region and Kargil region, they have said that no, we don't want 371. We want sixth schedule inclusion. We want full statehood for Ladakh. Release of Sonam Wangchuk and other detained protesters. What is important here from exam perspective is you have to go through Article 71, different provisions, which states are enjoying this. Certain portions. Tamil Nadu is not a part of Article 371. You have to remember it, guys. There's no other thing which I can do here. You have to go through it. You have to look at it like look at Angelina Jolie or Brad Pitt or Tom Cruise or Monica Bellucci or Sonam Bajwa. Guys, focus. Just like you look at their images, you have to look at this feature, this image, and you have to remember them all. Very good. So Article 371, Part 21. Temporary provisions currently applicable to 12 states, not as exhaustive as 6th schedule. It does not give as much power, as much autonomy as 6th schedule, and that's why people are saying that we don't want it. Keep it with you, government. We don't want Article 371 for that reason. So MHA is saying that okay, we will think about 6th schedule inclusion right now. 6th schedule currently for 80 mm. Wow. Assam, Tripura, Meghalaya, and Mizoram. Cheaper days. MCQ. Consider the following statement regarding recent Ladakh civil society demands. You need all the options. Choose and go for option elimination. Whoa, whoa, whoa. So they have accepted Article 3, though they have not accepted. Third is wrong. So obviously A, 1 and 2 became the right answer. Very good. Article 370 of the Indian Constitution is related to whoa, whoa, whoa. Guys, pause me, unpause me. Pause me, unpause me. B. Temporary transitional and special provisions for certain state. Whoa, whoa, whoa. Which of the following states currently have special provisions? This is a tricky question. If you get this question wrong, it's fine. It's totally fine. So Tamil Nadu is not there. So eliminate Tamil Nadu, rest all are there under Article 371, different provisions. So 1 to 4, D. I love you now, Piriyadi Poina. I love you, Pranam Poina. Which of the following powers do autonomous district council under 6th schedule not exercise? Maybe you will be like, sir, you did not tell us everything. I told you certain stuff. Use option elimination, try to solve this question and become a transition yourself from a good boy to a good boy, good girl to a very good boy, a very good girl. Whoa, whoa. Hey, what is happening here? What am I doing? Sometimes I do things, guys. So they amend the constitution? Do you think they have that much power? That is a parliament, guys. So D eliminate it. Rest, you have to choose the best possible option, right? So D is wrong. They cannot accept. They can make laws. They can control their police. They can levy certain tax, but they cannot amend the Indian constitution. D is the answer. 23rd, Delhi High Court upholds FSSAI ban on ORS tagged drinks. So, what is happening right now? FSSAI, Food Safety and Standard Authority of India, statutory body created by an act of 2006. Let's talk about this first of all, and then we'll talk about the issue. Food Safety and Standard Acts. Under Ministry of Health and Family Welfare, but the chairperson is appointed by central government and he is not Director General of Health Services. Please remember, this FSSAI is not under Director General of Health Services. There is a chairperson appointed by central government. Independent statutory body, it is under MOHFW, headquarter New Delhi. This Food Safety and Standard Act 2006, via which FSSAI has been created, it has subsumed many acts like Prevention of Food Adulteration Act, etc., etc. Now, what is important here? There are many drinks in currently. FSSAI has been, you may have seen many YouTube videos where people are like, this has been labeled this and that. FSSAI is not looking into it. So there is a severe shortage of staff also, which has been highlighted by PAC. Public Accounts Committee. So what was happening was this rebalanced Dr. Reddy, they were selling some fruit juice and God knows what, packaging them as ORS. ORS is not fruit juice, guys. ORS is a mixture of water, salt, different nutrients in certain proportion. Not every fruit juice, this and that can be labeled as ORS. So that was the complaint against Dr. Reddy. God knows whether they have removed ORS label now or not. But Delhi High Court is saying FSSAI banned them that you cannot use ORS on your fruit juice and fruit-based non-carbonated ready-to-drink beverage. ORS has to satisfy certain pharmacological ORS, like standards. Not any and every drink can be stated as ORS, guys. This is so wrong. They challenged this in Delhi High Court, and Delhi High Court was like, no, FSSAI is right here. And what is important here? FSSAI, it has been established by which act? It is not under the charge of Director General of Health Services. They have a chairperson, 22 members from different ministries. They come under their nodal ministry is MOHFW. Keep these points in mind. PAC is also auditing FSSAI. There is severe shortage of manpower in, FSSAI. Where it is not, like most of the government bodies, they are suffering from severe shortage because government does not have money for government jobs. Foreign tools and all that, they are more important. Now I'm not going there. Guys, I love Upiriadi Poina. Food Safety and Standard Act replaced the Prevention of Food Adulteration Act, correct? So we are left with ANC. Food safety is under the charge of, I've just told you, it is not under the charge of Director of Health Services. It is under Union Ministry of Health and Family Welfare, but it is not under Director General of Health Services. There's a chairperson appointed by central government. So not under, not. So second is wrong. So the answer is A1 only. Whoa, guys. Which of the following correctly describes ORS? Choose the best option. Pause me and pause me, pause me and pause me. A medically formulated mixture of salt, glucose, and water used to treat dehydration. Very good. 24th associated with FSSAI only. 22nd means November 2025. PAC. Here, Public Accounts Committee. What you have to do, there are different committees. Public Accounts Committee, Estimates Committee, Committee on Public Undertakings. Estimates Committee has largest members, 30 members. PAC and Committee on Public Undertakings, 22 members, 15, 15 from Lok Sabha, 7 from Rajya Sabha in both PAC as well as Committee on Public Undertakings. Or Estimates Committee, all 30 members from Lok Sabha, biggest committee in Parliament, and they are checking how much money government is spending, etc., auditing CAG reports, and then they're also seeing how government instruments are functioning or machineries are functioning or government authorities are functioning. Like they've seen FSSAI, they are having severe shortage of staff. So why? PAC referred to CAG report that pointed out a severe manpower shortage within the FSSAI. So what is important here is revise FSSAI again. That is good because UPSC has already asked PYQ on FSSAI. At the same time, PAC, Estimates Committee, Committee on Public Undertakings, all these things you have to revise and become a very good boy or very good girl. Whoa, whoa, whoa. So this is for your reading. Read it in your free time. Let's solve some questions. PYQ UPSC 2014, largest committee of the parliament. I've just told you what is the answer, guys. Chepade Cheputadzu ledu. Kadu. Answer is Committee of Estimates, B. FSSAI was established under which of the following? Chepandis Chepu Telsu Ledu. The Food Safety Standards Act 2006. Last article of the day, guys. 25. Rest 25 in two other parts of polity and governance coming very soon. And not very soon. We have to cover news till, April, 24th April, 1 month before. If prelims is on 24th May, we will cover current affairs till 24th April. So what happened in the second part? We covered September, October and November articles. In third part, which we will be covering articles from 36 or 26 to 37. So they will be mainly from, I'm not saying all, they will be mainly from December, January and February. So February has to go away and then only in March we can come with part 3, right? So yeah. Judiciary cannot type. So presidential reference. It's like there was a judgment given by 2-judge bench of Supreme Court earlier that the governor cannot sit on a bill indefinitely and he has to pass within 3 months. Then Supreme Court passed this presidential asked opinion from Supreme Court, or like president asked opinion from Supreme Court under 16 presidential reference under Article 143. Different southern states like Tamil Nadu, Kerala was like, no, this is actually an appeal against this Supreme Court judgment. But Supreme Court was like, no. President has power to ask questions on different matters under Article 143. Under Article 143, Clause 1, she can ask about different, Supreme Court opinion on different issues which is arising day to day arena. And then 143 clause 2 is about pre-constitutional treaties and all. In 143 1 clause 1, Supreme Court may or may not give advice to president in the and this is discretionary. On the other hand, 143 clause 2, Supreme Court has to give advice to president. In both the cases, advices are not binding on president. Remember these facts. So a 5-judge bench is saying that no, we cannot impose uniform timelines as 2-judge bench has earlier done, 3-month timeline for governor president. We cannot do that, because it will violate separation of power. You have legislature who will make laws, you have executive who will implement laws, you have judiciary who will check constitutionality of laws and executive orders. So we as judiciary cannot put limits on executive how much time they can take and not take, but ideally they should not sit indefinitely on bills. They should avoid prolonged and evasive inaction. If they keep on doing that, maybe we can issue a limited mandamus to governor and all. Why are you sitting on a bill indefinitely? But that is a question altogether for a different time. We cannot put limit on a time limit like which was done earlier. Tamil Nadu and Kerala was saying that no, this reference is not a presidential reference. President is not asking for advice. This is actually an appeal against that April judgment, where Supreme Court 2-judge bench, they said the 3-month timeline. So governor options under 203 or Article 200 has been clarified. They can give assent, they can reserve bill for president or return the bill for reconsideration. Cannot stall a bill by simply withholding assent indefinitely. They cannot do that. Now there is a homework for you people, guys. Read about pocket veto, suspensive veto, absolute veto, qualified veto, and if you know, you can tell in the comment section which of the out of those 4 vetoes is not applicable in India. Withholding a bill without returning it violates federalism. If governor must have a dialogue, tell state legislature what problems they have. They cannot sit on a bill indefinitely. If they do that, maybe if there is a prolonged, unexplained, indefinite inaction, court may issue a limited mandamus. Mandamus means we command. One of the writs issued, like mandamus, habeas corpus, certiorari, quo warranto, prohibition. Revise all those writs, guys. Governor personally remains immune under Article 361. Article 361 provides that governor is immune from all the official work which he is doing in his capacity and all. Courts cannot review the merits of governor decision under Article 200, but if they sit on a bill indefinitely, maybe limited mandamus can be issued. No fixed judicial timelines because bill differs in complexity. That was what 5-judge Supreme Court said, or bench of Supreme Court said actually. Oh my god, I'm tired, guys. I love you know period. Article 143. Supreme Court's opinion under Article 143 is binding. No, it's not binding, it's advisory. So first is wrong. You're left with B and C, just check the third one. Article 143 makes it mandatory, yes. 143 for president to refer disputes arising out of yes. And in that case, Supreme Court also has to give advice. So B is the answer. Which of the following best describes Supreme Court views in 16 presidential reference? Governors cannot be compelled to allow a one-size-fits-all judicially fixed timetable. Which of the following statements correctly differentiate Article 143 Clause 1 and 143 Clause 2? C. Article 143 Clause 1 discretionary, Article 143 Clause 2 is mandatory. Pre-constitutional treaty, Supreme Court has to render advice to President. And 143(1), not like Supreme Court may or may not give advice. Like, share, and subscribe, guys. Spread the word. You are your own competition. You are not competing with anybody else. Keep that in mind. What else? If I'm, adding to your knowledge base, you can donate at this number. If you want this PDF, again, you can send me a message at this number only. That's it from me. Take care. Be blessed. I will see you soon.